didn't see you there. Just kidding. I pressed play on the camera. Of course I saw you there. Welcome back to my channel. Today is another legal fitness video for you guys. Today's episode, if you cannot tell from the title, is all about trademarks. Before I get started, I just want to let you know that in the description box is going to be an outline for the video. I did the same thing in my last legal fitness video. That way, if you had questions on anything or you just missed something, because sometimes I speak really fast or not very clearly, and I'm using my phone so the microphone may not be the best. That way you can just kind of go through it and you can copy paste from the box and save it for later. So I'm going to do the same thing on this video and probably every video moving forward. The next thing I want you to know that is my email address is going to be in the box below as well. If you have further questions, if you just want to go over something specific to your situation, feel free to shoot me an email. I would be happy to help you as best as I can. And of course, if you want to work with me one-on-one and go that route, definitely send me an email. Time for my disclaimer. This video and every video in the legal fitness series is information and not legal advice. I am a lawyer. I am licensed in the state of Florida, but I am not your lawyer. Everything I'm going to discuss, especially in today's video, is going to be based off of US law, but I will be sure to point out where the laws might vary in your state and when hiring an attorney locally could be very beneficial to you. So all of that said, let's get started with today's video. All right, intellectual property, or IP as it is known in the legal world. I'm sure you've heard of it. I'm sure you've wondered what the heck is intellectual property. Well, as a business owner, and really anybody with an online presence, intellectual property is one of your most important assets. You may have heard the terms patent, copyright, trademark, and even things like trade secret or trade dress. Those are all considered intellectual property. I am not going to discuss patents today because I'm not a patent attorney. In order to become a patent attorney, you have to take a separate bar exam and you also have to be an engineer. I did not do that. I am not an engineer, so unfortunately for me, I will never be able to be a patent attorney. Patents mostly deal with inventions, processes, manufacturing, designs of things. If you think like Mark Bell's slingshot, that sort of thing, that's going to be an item that can be patented, and I just don't have that experience. What is a trademark? If you have a brand name, a logo, a company symbol, even a slogan, those are things that are going to be trademarkable. A trademark is going to be something that when you see it or you hear it, it is going to immediately have the consumer think of a certain company or a brand. Trademarks are an essential part of your business. I mean, very, very essential. They represent your goodwill, your reputation, and how consumers and the general population perceives you as a company or business. They're how people tell the difference between you and somebody else, and also how people tell the difference between what you offer and what somebody else offers. So when you have something like this that's important, like your brand name, you're going to want to register that, and you do that with the USPTO office. So the USPTO, I will put a little clip right here of the website. The USPTO just stands for US Patent and Trademark Office, and they're the ones who are responsible for reviewing a trademark application and approving it. Now, you can stop people from using it even if you don't register, but registering it, particularly with trademarks, is going to give you so many more benefits that it's really silly not to try and register it. Before we even get to the point of being able to register a trademark, you are starting this business. And the most important thing you're going to want to think about when you're starting this business is, what is a name that I can come up with, or what is my slogan, or what is my brand going to be, because you want it to be trademarkable. If it isn't trademarkable, and I'm going to explain the reasons why it wouldn't be, you're not going to be able to protect yourself. You're not going to be able to protect your brand from other people using it, diluting it, all of that stuff. So when you're choosing the name for your business or products or services, you're going to want to do a full-blown check. I mean, a huge check. This is so important to make sure that nobody else is already using that. Because in the United States, in order to get the trademark protection, it's based off of actual use. So it's kind of first person to use wins, whether they're registered or not, because as I mentioned, you don't have to actually be registered to garner the protection of the trademark laws. The second that you start using it in commerce connected with your business, your product or service, those protections fall into place as long as there isn't somebody already using it and it's not already registered. And that's why doing the search is so important. You can't have this great idea for a business and start doing all these things working under a name that's already being used. At that point, the person who's already using it, they're going to win and they can stop you from using that name. Or maybe they leave you alone, but there's no chance that you would ever be able to stop somebody else from using that name. So it's going to be really important that you do more than just a simple, say, domain name search. So the domain name search is great. Do that, and if nobody's using your domain name, then there's a good chance that there isn't a business under that name, but it's not a guarantee. So after you do your strict domain name search, you're going to want to do super extensive research in the marketplace. Now, trademark law is a little tricky in that you can have the same name for something if the products and or services are two totally completely different things and no confusion would ever be caused amongst consumers. So for all of my fitness entrepreneurs out there, if you have a clothing brand and it's called Deadlifts or Bust, and all you do is make fitness clothes. You make t-shirts and sweatshirts and pants and whatever. And on all of this clothing is a logo that resembles fitness or bust in some way. And there's a guy down the street who owns a coffee shop and he calls it Deadlifts or Bust. I don't know why you would name a coffee shop that, but whatever. He really likes deadlifts, and so that's what he named his coffee shop. Those are going to be two very different things. There could be an argument made that somebody might assume that the coffee shop and the clothing brand are connected, but it's not likely that that's going to happen. So that's an instance where if you are researching and you find a name similar to what you want to use, but it's something completely out of the market that you're in, you may be okay. But this is one of those times when hiring an attorney would be really important. So a good place to start to do that marketplace research is going to be Google. That's the simplest and easiest way to do these things nowadays. You're gonna wanna go past like the first couple pages. You're gonna need to go as far as the Google will allow you to be sure that you vet out all of the suggestions that it's giving you. You're also going to wanna try different spellings of your business name, and you're also going to wanna try different, maybe invert the words. You're going to wanna try all the possibilities that you can think of to search this, okay? So if you don't find things that are exactly the same, but you still have questions as to whether or not you would be infringing on someone else's business by using your chosen name, the standard in trademark law is, like I just said, whether or not a consumer would be confused. So with my coffee clothing example, is there going to be confusion if they're on the shelf next to each other? One's, maybe the coffee company decides to sell coffee grinds, I don't know, and some sporting goods store because it's called Deadlifts or Bust. Would the consumer be confused when they looked at the one product versus your t-shirt? Maybe, because the way the industry is, everybody's making everything nowadays. There isn't really a black and white answer, but if you do come across this scenario where you've thought of the best name possible and you've done your search and you found one company that's somewhat similar sounding to yours, do that test. Would the products or services get confused? Would it cause confusion in the marketplace? If it would, then I'm gonna say probably you should come up with a different name for your company. And then you're going to check your state's website. Each state, I believe I've showed you in the first video, the Secretary of State website for Florida. That's going to be where you would look for something like this. So every state's going to be different, but just a simple search, like a business search, you can go on there and check to see if anybody's registered their trademark with the state. And then finally, you're going to go to the USPTO website, which was shown a few shots ago, and you're going to search on there. If there are trademarks remotely close already registered, then I would say you're going to need to reform your business plan. Okay, so at this point we have thought up of a great business, we thought of a great business name, and we've done our search, we've done the due diligence, and we don't see anybody else out there in the marketplace currently providing our product or our service with the name that we have settled on. So everything's great, and now you're going to start using that business name. I know that the common law is going to protect you if you don't register, but here are some reasons why I think you should. It will allow you to use the mark nationwide, not just in your state. You're going to be able to sue in federal court for any infringement on your trademark. You're going to be able to recover more damages, and that just means more money. In the event that you do have to sue somebody, you're going to get more money if it's registered. You're putting everybody on notice that this is your mark and that you're using it and that it belongs to somebody, and it's going to keep other people from wanting to use it naturally. And finally, after 5 years of registration, the mark becomes incontestable. So you have the exclusive right to use it, and your right to use it becomes conclusively established. And all that means is that after 5 years of registration and keeping it up with your registration, nobody else can ever try to argue with you in court that the mark belongs to them. You will win every single time. The registration process is actually relatively difficult. The process for approving trademarks is actually kind of adversarial. They have all these attorneys sitting in a giant office somewhere reviewing all of these applications, and really what they want to do is say no to you. They don't want to approve it because they're giving you a monopoly on the use of that trademark. And here in the United States, we don't love monopolies, right? They still want you to be able to do it. They just want to make sure that it is basically perfect. So with your application, although when you hop online and you review the application and there's 15 videos about how to do it, and they're pretty good videos, it's just still so tricky that I think it's in your best interest to go ahead and hire an attorney for this part. But if you do want to do it on your own, it can be done. You just have to really take the time to research it. The general filing fee for these things is about $225. And that's going to be for each good or service that you're registering the mark to. So for example, if you want to print t-shirts, coffee mugs, and handbags with your logo on them, that's 3 different filing fees because that's 3 different types of goods according to the USPTO. So that's going to be kind of expensive. But you have to keep in mind that you can only keep people from using the trademark on things that you're actually using the trademark on. Somebody came in and wanted to use the trademark on bath towels, most likely they're going to be able to. So just keep that in mind, especially as a fitness entrepreneur with the way the fitness industry is going. People are developing products and services left and right, and tons of different offerings with their one brand. So when you go to register these things, if you're already using your logo on 15 different formats, that's going to be 15 different filing fees, and it's going to be relatively expensive, which means you don't want to screw up the application because you're already spending a ton of money on it, so maybe you should hire an attorney. If the USPTO denies your application for whatever reason that they find, whatever nuance you missed, you're going to lose all that money and your application is denied. So hiring an attorney is probably your best bet. So a few miscellaneous things with trademarks. The TM mark that you see on everything, that can be used next to your logo, anywhere that it's printed, even if your logo isn't actually registered. So you can put that TM next to everything when you start working so that people know that you're asserting your rights in your intellectual property, that you've done the research, that you know there's nobody else in the marketplace using this and now it's yours. So put that little T in there, and then everybody knows that you are asserting your rights. After you register, because you are going to register these things, you can do the R in the circle. And that lets people know that it's a registered trademark, and it's even more of a no-no to try and infringe on that. So we're going to move on to our second intellectual property topic for today, which is the right of publicity. For you guys out there, particularly the social media influencers or people who are aspiring to be that, the right of publicity is going to be very important for you. Right now, everybody's creating their own personal brand with each and every single post that they put up on Instagram or Facebook or Snapchat, and your name and your face are really important to that brand, right? Because the brand is you. With the right of publicity, you have the right to protect your name, your face, your image, and keep other people from using that. This is a state law right, and it's going to be strongest in states that have a really high entertainment industry, like New York or California. Depending on where you live, you're gonna wanna kind of look into the right of publicity there in your state. You have the right to control who is using your face and your name and what we call your likeness. If you right now are working really hard to build up your brand and your social media following, and you are on your way to becoming the next big social media influencer, make sure that if you see somebody using your image, you have the legal right to stop them from doing that. And even if you don't have a personal brand associated with your name and your face, then it's still going to be important for you as a business, because when you're marketing things, you need to be very careful of who you're using to market things. What images you're using, who they belong to. Those are intellectual property considerations that you need to make before you make a post for your brand. If you don't have permission to use someone's picture, don't use it. Here in Florida, they have both the statutory and common law right to publicity to protect your name and likeness from being used for commercial purposes. So that is good. That means you don't have to take any action to actually have the protections. Okay, so that is going to wrap this discussion on trademarks and the right to publicity up. If you have any questions, leave them down below or send me an email. I really hope that you were able to get something out of this video. Like I said, the outline is going to be in the comments below. Next week, we're going to talk about copyrights, which is another form of intellectual property. And a lot of people in the fitness space probably aren't aware of exactly what they have that is protected by copyright law. So stay tuned for that one. Subscribe, hit the thumbs up button. I keep forgetting to say that. If you've liked any of the other ones, go ahead and thumbs those up. That is it for today. I will see you guys later.